The first time Karen Doyle got away with something, it cost a widow 4 acres and cost Karen nothing at all. That's the part people never hear about, and it's the part that makes what eventually happened to her feel less like luck and more like a debt finally getting called in after years of interest. 4 years before she ever came from my farm, Karen, HOA president, and, less publicly, a notary public who handled closings and paperwork for half the development, notarized a boundary release for that widow's property, a document the widow swore on everything she had that she never signed. The widow couldn't prove it. Her signature looked close enough, the ink had aged evenly enough, and Karen's notary seal made it official in the eyes of the county the moment it was stamped. The HOA quietly absorbed 4 acres of the widow's backlot. Nobody was punished. Karen kept her commission, kept her seal, kept doing paperwork for the entire neighborhood, trusted with the one thing a notary is supposed to guarantee above all else, that the signature in front of her is real, that the person signing is who they claim to be, that the moment is exactly what it appears to be on paper. I didn't know any of this when I inherited my uncle's 200 acres. I found out the way most people find out things about Karen Doyle, after it was already too late to stop her from trying the same thing on me. She came from my land 18 months ago, but not with lawyers or surveyors first. She came with a document, and she came alone, which in hindsight should have told me she wanted to control the room before anyone else could weigh in. It was a deed of community donation, dated 11 years earlier, supposedly signed by my uncle, granting 60 acres of the eastern pasture to the Homeowners Association in exchange for lifetime maintenance of the private access road that ran along our property line. My uncle never mentioned it, not to me, not to his lawyer, not in any will or estate filing, not in the ledger he kept for every transaction going back to 1987. But the document had his signature, a date, and, this was the part that made my stomach drop the moment she slid it across her kitchen table, Karen's own notary seal and signatures certifying the whole thing as legitimate. She told me almost gently, like she was doing me a kindness, that she understood this was a shock, that she'd only recently rediscovered the filing while organizing old HOA archives, and that she hoped I'd do right by my uncle's wishes without forcing the association into an ugly legal fight that would only cost us both money. I fought it anyway. My uncle's handwriting, even near the end of his life, had a distinctive hook on his capital letters that this signature simply didn't have. A small thing, but the kind of small thing a person who watched him sign 1,000 feed receipts would notice immediately. I hired a document examiner privately on my own money who told me the signature was consistent with forgery, but that without a live comparison to an actual forger's known hand, a civil court might not find that persuasive enough to overturn a notarized instrument. Notarization carries real institutional weight. That's the entire design of it. A stranger's stamp exists so you don't have to take anyone's word for it. Karen understood that better than almost anyone alive because she'd built a small, quiet, patient career on exploiting exactly that assumption, one file at a time, never taking enough from any single person making the fight worth their while.
2 months into that exhausting, expensive fight, I got a federal jury summons. Unrelated, as far as I knew, pulled at random from the general county pool, the same as any other resident. I nearly asked for a deferral. I was in the middle of assembling a legal case and didn't have the bandwidth to sit in a courthouse for a total stranger's trial, but the clerk's office denied my request, and I reported on a Monday morning still worn thin from arguing with my own attorney about handwriting analysis and the cost of forensic testimony. The case, it turned out, was a fraud prosecution against a notary public who had spent nearly a decade forging estate and property documents for elderly and vulnerable clients across 3 counties. Backdated deeds, fabricated donation agreements, falsified boundary releases, always small enough that no single victim's loss looked big enough to justify a fight, always notarized with her own legitimate seal so that every fraudulent page carried the county's full institutional trust behind it. I sat through the opening statements without connecting any of it to my own life because the defendant's name meant nothing to me. It wasn't Karen. It was a woman 2 counties over I had never once heard of, who Karen, it emerged over the following days, had trained under 15 years earlier and stayed close with ever since. Two notaries who had learned the trade side by side and, prosecutors alleged, occasionally traded referrals whenever a job needed a cleaner, more convincing signature match than either of them could produce alone. The connection surfaced on the fifth day when the prosecution called their forensic document examiner to walk the jury through a pattern she'd identified across dozens of suspect files. A particular tell in the way this ring forged signatures, a habit of using a slightly too steady, slightly too deliberate pen stroke that gave away every fake to a trained eye, even when it fooled everyone else. The examiner had built a reference file of documents suspected to be part of the wider scheme, pulled from public county records as investigators tried to map how far the pattern actually reached. And on the screen, projected for the jury as one of roughly 40 comparison exhibits, was a deed of community donation from my own county, my uncle's supposed signature, Karen's notary stamp sitting beside it, dated exactly the way I remembered from the document still folded in a manila envelope in my truck. The examiner had no idea whose land it was. She was there to testify about the stroke pattern, not the story behind it. I was the only person in that jury box who understood in that instant that I was staring at my own case, quietly entered into a federal trial as evidence against someone else's decade-long crime.
I didn't say anything during deliberations that would have compromised the trial. I recused myself from that specific portion the moment I recognized the document, reporting it to the judge privately, who excused me from continuing on that count while keeping me seated for the remainder of the case. What I did do, once excused from that narrow piece, was hand my own private examiner's report to the federal prosecutors, who added my uncle's deed to their exhibit list as a fresh, previously unknown instance of the pattern, and subpoenaed Karen directly, no longer as a bystander, but as the notary of record on a document now tied to an active federal forgery conspiracy. Karen was sitting in that courtroom the day the subpoena reached her, watching her old training partner's trial the way a person watches a fire creeping toward their own house. I watched her see the exhibit go up on the screen. I watched her understand in real time that the deed she'd handed me across her own kitchen table, so certain no forensic comparison would ever reach it, had just walked into a federal case as a matching sample against her. She was indicted 4 months later on 2 counts of notarial fraud and 1 count of conspiracy, tied not only to my uncle's forged deed, but to the widow's boundary release from 4 years earlier, which investigators reopened once they understood how far back Karen's pattern actually went. This time, there was no $900 filing fine standing in for justice. She was convicted on all 3 counts. The judge, sentencing her, specifically cited the widow's case as an aggravating factor, a first offense that had gone entirely unpunished, and, in his words, taught this defendant that her seal was worth more than her victim's word, a lesson she spent the next decade putting to use. She received 6 years, permanent revocation of her notary commission, and a restitution order that took her own home, sold at auction to repay every documented victim, including the widow, who finally got the apology Karen had promised her in writing and never delivered, this time compelled aloud in open court as a condition of her plea on the lesser counts. My uncle's 60 acres came back to me by court order within weeks, the forged deed voided and struck from the county record permanently. I still keep the document examiner's original report in the same drawer where my uncle kept the deed to the whole farm, because it's the only proof I have that a signature exactly like his, sitting in a county file for over a decade, was never actually him at all.